To find out more, I spoke with Katherine Rayden, founding partner of Rayden Solicitors. Katherine has over 20 years' experience as a family law solicitor and specialises in complex financial disputes with an international element, prenuptial agreements and expatriate divorces. Katherine is a member of Resolution and currently sits on their Skills and Support Committee. Striking out under ground A of Rule 4.41 relates to where the statement of case discloses no reasonable grounds for bringing or defending the application. In what circumstances will striking out be appropriate under ground A?
The practice direction gives some guidelines and circumstances that could be relied upon, but these talk about incoherency or the application not being properly pleaded. In the case of T versus M 2013, the court did not apply those particular circumstances and instead just looked at the circumstances of the case they were listening to.
And what about for ground B, where it's argued that the statement of case is an abuse of the court's process or otherwise likely to cause an obstruction to the just disposal of proceedings?
Again, an abuse of the court process will often be dependent on the circumstances of the particular case. In terms of obstructing the access to the courts, Vincent Wyatt made it clear that a delay in bringing your application could hinder the judicial process because it could open the courts to a plethora of claims that would not otherwise arise because of the time that has passed between the parties.
Now, the courts don't seem to be swamped by striking out applications on the basis of ground C. So does this mean that for such applications to be successful, the failure to comply must be extreme?
I don't think it has to be extreme so much as obvious, and obvious without an excuse. There are lots of reasons why people don't comply with the court deadlines, and sometimes it is difficult to apportion blame to only one party if they took a long time to get the bank statements, or there was a change of solicitors, or their mother died. There are lots of reasons why an excuse might just have legs, and often practitioners would rather get on with the case and have a finding of adverse inferences or something like that later on than stop the whole process and issue an application. That said, the court are under pressure to show the Ministry of Justice that they are not wasting the public funds. And if the courts felt that there were too many applications or a process was continuing which had no merit and people were disrespecting order of the courts, this is always an order that's up their sleeve. And I think parties have to be very careful to disregard orders from the court, because you never know when a judge is going to say enough is enough.
Now, striking out under Rule 441 can be applied for by either one of the parties or under the court's own initiative. In what circumstances can the court do that, and what's the procedure that it has to follow?
Generally, the judges are trying to have a more active case management role, and certainly in the Principal Registry in London, they are trying to follow a case as it goes through the process. This means that if an application comes before the judge and he considers it to be a satellite or an interlocutory application that has no merit, then a good judge will try and strike it out there and then. I don't think that parties are going to see many courts striking out a substantive application, an application for financial relief at the beginning of the court's own volition, because that would be far too early in the process. But particularly in cases where there are litigants in person, quite often raising cases of human rights or defamation or actions that you would not normally see in the family process, the courts may well take a step to marshal the case and to make sure it follows a more conventional route.
And Part 18 of the FPR governs the procedure for striking out under Rule 441. What is the procedure?
The magic word is as soon as possible. Make the application as soon as you can, ideally before the first appointment. In the case of Crossley, that is a prime example of how it was used, because they used the striking out application procedure, even though at the time they weren't relying on these rules, to say to the judge, let's not even have a first appointment, let's deal with the particular issue. In that case, it was whether a prenuptial agreement should apply. So do it as at the very beginning of your case, as part of the strategy at the beginning, rather than just tapping it on. Because if it looks like you're doing it because you're unhappy with the disclosure you've been ordered to produce, or you're doing it in response to something, it won't look like a genuine strikeout application. And when you make the application, please read Part 18. When you prepare the application, say what you're seeking, provide a draft order, and make it very clear what you're doing and how you want the court to assist you.
And in your opinion, what factors are likely to support an application for striking out, and what factors are likely to undermine the making of such an order?
At the moment, there aren't that many applications reported, and so when a case is being reported, I think the courts are very aware of the impact that the application has on the rest of the cases and society before it. In Vincent Wyatt, it is a preoccupation of the courts that if they allow an application to be made after a long period of delay, it could open the floodgates to a lot more litigation. And this, I think, is a theme behind a lot of the basis of these applications. The courts are under a lot of pressure not to have unnecessary cost, not to have unnecessary applications. And so delay is the biggest watchword in the whole of this theme. They're not going to tell you precisely how long the delay is, although Mostyn talks about 6 years and what have you. It depends if you can justify it. And if you have plodded along perfectly happily in your life and now are making an application and trying to get some more money than you were otherwise expecting, the courts are saying, be careful. The courts are not going to grant you a windfall if you've been managing perfectly well. If, on the other hand, you've been separated from your husband and there has been a tacit understanding that nothing will happen until the youngest child has reached 18, then that's a very different set of circumstances. And although nothing might have happened for 10 years, you'll be able to say to the judge, well, that's because for 10 years everything had to stay stable for the children. It's whether the courts think that they are being asked to give you something for nothing. So the factors in support of a strikeout application would be to do with the timing. If it's too long between making an application and submitting it, then that will help your case. Alternatively, if it's too short a period, as in T&M, that was only 4 months, that could support an application for strikeout. Also, if there's a particular unusual circumstance like a prenup or a postnup that is valid, that would be an important factor to justify a strikeout. What you're looking at is evidence of a contrivance. And so if there is a factor that you say that was present between the parties that everybody knew about, and now the new application ignores that factor, then that's what you use. Conversely, a factor that might be present that could diminish your chance of a strikeout application working is if there's evidence that things aren't quite clear cut, if there's a commingling of assets, if you carried on having a joint asset that you clearly didn't get round to resolving, then you can't say to the court, this is clear cut, it doesn't need your interference. And another factor could be the presence of minor children. It's very difficult to say that matters are resolved and the courts don't need to interfere if there's still some young children involved, because circumstances often change. It's just important to look at what the reality of the situation is between the parties involved.